Time it is. Please understand, any information that's contained in any of my videos does not constitute legal advice. The information that I share comes from my personal experiences and personal understanding. It is not to be taken for legal advice in any shape, form, or fashion. Man does not need a license to share his personal experiences with others. Now, please understand, the information I share is thought-provoking, and it is done intentionally because a lot of us don't understand what's really going on, and I've used myself to be an advocate to share the truth with the people. So with that being said, let's go ahead and get to the content. Thank you for that, Claude. I have a question for you. What does the Federal Reserve Act, Section 401, 6th paragraph, subsection 18 state?
Unfortunately, I do not have the full text of the Federal Reserve Act to reference the specifics of Section 401 as you ask. However, in general, promissory notes are written, signed promises to pay back a specified sum of money by a specific date. They can be issued by individuals or entities as a way to formally acknowledge a debt obligation. Lawful money typically refers to forms of legal tender money issued by the United States government, such as Federal Reserve notes or coins. This is money designated as valid for the payment of debt and taxes. Obligations that are directly owed by the United States government would be things like Treasury securities, bonds, notes, bills issued by the Treasury. These are direct debt obligations backed by the full faith and credit of the federal government. The Federal Reserve itself issues Federal Reserve notes, paper money in circulation, which serve as legal tender. However, these are obligations of the Fed and liability of the Fed, not formally direct obligations of the U.S. government itself. Without seeing the exact text and context, I cannot confirm if the section you reference makes any definitive statements about promissory notes and redeemability specifically being direct obligations of the United States government. But in standard finance, personal corporate promissory notes and formal U.S. government debt obligations are distinct instruments. Let me know if you need any clarification or have additional questions.
Okay, Claude, no problem. Let me be a little bit more specific. Are promissory notes redeemable in lawful money pursuant to the Federal Reserve Act, Section 401, as direct obligations of the United States?
Unfortunately, I do not have the full text of the Federal Reserve Act readily available to directly quote Section 401, paragraph 6, subsection 18. The Federal Reserve Act is long and complex legislation that establishes and governs the Federal Reserve System in the United States. Without more context about what specifically you are looking for in Section 401, 6.18, I would not want to guess or summarize what that particular subsection states. Let me know if you have a more specific question about the Federal Reserve Act or a link to the full text so I can take a look and assist further.
Well, actually I do. What law states a distinction between personal, corporate promissory notes and formal U.S. government debt obligations of the United States government itself?
There is no single specific law that clearly distinguishes between personal corporate promissory notes and formal U.S. government debt obligations. However, some key differences and relevant laws are: personal corporate promissory notes are not considered legal tender. They are a private financial instrument and contract between two parties. The U.S. government issues notes and coins that are designated as legal tender under 31 U.S. Code Section 5103. U.S. Treasury securities like Treasury bonds, bills, and notes fall under different regulations as assets issued and guaranteed by the federal government itself. Relevant laws include the Second Liberty Bond Act of 1917, the Public Debt Acts of 1941 and 1975. These established Treasury securities as direct government obligations. The Uniform Commercial Code, UCC, in particular UCC Article 3 on negotiable instruments, covers general rules and laws around notes, drafts, checks, and other financial instruments. This establishes enforceability of promissory notes between private parties, compared to Treasury securities which rely on the full faith and credit of the U.S. government. Federal Reserve notes issued by the Federal Reserve as the U.S. paper currency falls under Federal Reserve regulations and the Federal Reserve Act. While this establishes Federal Reserve notes as legal tender, they differ from Treasury securities as direct government debt. So in summary, there's no one law that neatly distinguishes these types of instruments, but the obligations, legal tender status, and backing differ based on multiple state, banking, and federal regulations. The issuers and backers are the key distinction. Let me know if this helps explain or if you need any clarification.